പറഞ്ഞോ.
A very good evening for everybody. നമ്മളിന്നിപ്പോൾ പ്രധാനപ്പെട്ട നമ്മുടെ സമകാലീന നമ്മുടെ ജീവിതത്തിൽ വളരെ പ്രധാനപ്പെട്ട ഒരു സെഷനാണ് ഇന്ന് നമ്മൾ ഓർഗനൈസ് ചെയ്തിരിക്കുന്നത്. അപ്പോൾ ആദ്യമായിട്ട് നമ്മുടെ സ്റ്റേറ്റ് പ്രസിഡന്റ് വന്നിട്ടുണ്ടോ? സ്റ്റേറ്റ് പ്രസിഡന്റ് ഇല്ലെന്ന് തോന്നുന്നില്ലേ? ഓക്കെ, അപ്പൊ അങ്ങനെയാണെങ്കിൽ എല്ലാ സംസ്ഥാന നേതൃത്വത്തിനും ഈ സെഷനിലേക്ക് ഞാൻ സ്വാഗതം ആശംസിക്കുന്നു. അതുപോലെ തന്നെ സ്റ്റേറ്റ് അക്കാഡമിക്സിലെ ഇത് ഓർഗനൈസ് ചെയ്ത സ്റ്റേറ്റ് അക്കാഡമിക്സിലെ എല്ലാ മെമ്പേഴ്സിനെയും ഞാൻ ഈ സെഷനിലേക്ക് സ്വാഗതം ചെയ്യുന്നു. അതുപോലെ തന്നെ നമ്മുടെ ഇപ്പോൾ ഉള്ള എല്ലാ ജില്ലാ നേതൃത്വങ്ങളെയും ഞാൻ ഈ വേദിയിലേക്ക് സ്വാഗതം ചെയ്യുന്നു. അതുപോലെ തന്നെ ഏറ്റവും പ്രധാനപ്പെട്ട ഡോക്ടർ ജോർജ് സി വിളനിലം സാറിനെ ഞാൻ വളരെ ഹാർദവമായി നമ്മുടെ ഈ സെഷൻ നയിക്കുവാൻ ഈ സെഷനിലേക്ക് ഞാൻ സ്വാഗതം ചെയ്യുന്നു. അതുപോലെ തന്നെ ശ്രോതാക്കളായി വന്നിരിക്കുന്ന എല്ലാവരെയും ഞാൻ ഈ സെഷനിലേക്ക് സ്വാഗതം ചെയ്യുന്നു.
Dr. Praveen, രണ്ട് വാക്ക്.
Okay. So I congratulate the team KGMOA Kottayam for selecting this very important topic. നമുക്കറിയാവുന്ന പോലെ നമ്മളെപ്പോഴും പറയാറുണ്ട്, നമുക്ക് വളരെ ആശങ്കയുള്ള ഒരു കാര്യമാണ് മെഡിക്കൽ നെഗ്ലിജൻസ്. നമ്മൾ ഫെയിലിയർ ടു എക്സിക്യൂട്ട് എ റീസണബിൾ ഡിഗ്രി ഓഫ് സ്കിൽ ആൻഡ് കെയർ എന്നൊക്കെ പറയുന്നെങ്കിലും പലപ്പോഴും നമ്മുടെ ഒരു എറർ ഇൻ ഡയഗ്നോസിസ് ഒക്കെ ഉണ്ടാകുമോ എന്നുള്ളൊരു ആശങ്ക, പ്രത്യേകിച്ച് നമ്മൾ പ്രൈമറി കെയറിൽ വർക്ക് ചെയ്യുമ്പോൾ ഫസ്റ്റ് ഡേ കാണുന്ന പേഷ്യൻറ്റിൻ്റെ ഫൈനൽ ഡയഗ്നോസ് എന്തായിരിക്കും എന്ന് പലപ്പോഴും നമുക്ക് അറിയാൻ പറ്റത്തില്ല. അപ്പോൾ അങ്ങനെ ഒരു എറർ ഇൻ ഡയഗ്നോസിസ് ഒരു മെഡിക്കൽ നെഗ്ലിജൻസ് ഉണ്ടാകും എന്നൊക്കെ ആശങ്കകൾ നമുക്ക് പലപ്പോഴും ഉണ്ട്. അപ്പോൾ ഇന്നത്തെ പ്രോഗ്രാമിലൂടെ സാർ ഇതെല്ലാം എന്തൊക്കെയാണ് നെഗ്ലിജൻസ് എന്നുള്ളതും ഒക്കെ ക്ലിയർ ചെയ്ത് തരുമെന്ന് വിചാരിക്കുന്നു. ഓവർ ടു മാഡം. താങ്ക് യു.
Good evening all. Respected Kottayam KGMOA Secretary Dr. Ashik, distinguished speaker of the day Dr. George C. Vilanilam, members of the State Academic Cell Dr. Praveen, Dr. Vipin, Dr. Minu Krishnan, Dr. Abhilash, District Academic Cell members, and all my dear KGMOA members. With great honor and enthusiasm, let me welcome Dr. George C. Vilanilam, Neurosurgeon, Sree Thirunal Institute, and R. Madhavan Nair Comprehensive Epilepsy Care Center. First of all, let me thank Dr. Krishna Kumar, head of the Department of Neurosurgery, who is my classmate and close friend, for introducing Dr. George to me. A short bio about Dr. George. He did his MBBS from University of Mumbai, MS General Surgery from AIMS, Delhi, MCH Neurosurgery from NIMHANS, Bangalore, FRCS, Edinburgh, MBA Hospital Management from University of Madras, postgraduate diploma in medical law and ethics from National Law School, Bangalore. He was a former faculty JIPMA Pondicherry, and his mentor faculty epilepsy surgery program at SGPGI Lucknow, AIMS, and National Hospital, Colombo. He has a special training in pediatric epilepsy surgery at UCLA Los Angeles, US, and he has many research projects and publications in his credit. Awake brain mapping, epilepsy surgery, and AI in brain tumor imaging, medical law and ethics, bibliometrics. And he also has trained and mentored neurosurgeons for developing epilepsy surgery centers in India, Bangladesh, Sri Lanka, and Nepal. In today's discussion, let me give a brief abstract about the webinar. Today's discussion aims to clear basic concepts of medical negligence with a special emphasis on preventive efforts with survival and bailout techniques. The changes in the medical negligence laws in the current era of Bharatiya Nyaya Samhita when compared to the earlier Indian Penal Code IPC is of recent relevance to medical practitioners. A clear awareness of medical legal systems, evolving concepts that is in informed consent for medical care and norms of medical record keeping would also be part of the discussion. Overall, the session hopes to better arm medical practitioners to understand and overcome the challenges posed by medico-legal risks in routine medical practice and specialized intervention. It is indeed a privilege to have Dr. George C. Vilanilam with us today. Over to you, sir.
Thank you very much, madam. വളരെ നന്ദി. Actually, I think all of you at KGMOA are doing very fabulous work, and why we felt the need for this topic is because you are at ground zero. at the highest risk perhaps for this evolving concepts of medico-legal negligence to hit you on the wrong side. So I'm very grateful to Dr. Preeta, Dr. Praveen, and all the leaders of KGMA for giving me this opportunity to share a few ideas. I'm very sure that there are many of you here who perhaps may know a lot of practicalities of this topic much more than me. So the idea here is, just to spray all of your minds with to sow the seeds of the basic concepts, and then we can always expand on it further and discuss it further as we go by. So, these days it is a very big legal necessity when you start any publication. It is also fashionable to start with a disclaimer. So I will start with my disclaimer saying that I do not really sell any medical indemnity insurance. I do not work for any legal firm. I have a little bit of medical legal qualifications and a little bit of expertise of working on some committees of medical legal importance. And I'm just doing this, out of the noble intent to create a basic awareness about vulnerable moments, because we are all extremely vulnerable today. And then, even a small medical legal getting hit on the wrong side can be a heartburn for a lifetime. We also hope that we will, help you to avoid panic and to clear some misconceptions, and also create a very strong defense to absolve blame. So we live, at a time why this concept of medical legal negligence, medical negligence is coming up is because of these, two sets of people. So one set of people, some of us belong to this. We feel that we are very compassionate, we are skilled, honest, we are men and women of honor, we are highly accomplished. And, we always feel that, medical legal and ethics, everything is too philosophical, abstract, and it is not for me, So I'm already very quite ethical and legal. Legally sound. Okay. And on the other hand, so if many of you who belong to this category, let me begin by telling you a true story. This is something which happened in Delhi a few years ago. There was a middle-aged lady who had presented with a metastatic malignancy, primary unknown. So she had lesions all over the liver, in the brain, and she presented with intestinal obstruction, probably because of metastasis. She went to many hospitals, and almost all of them said that, we can't cure this, so we are not going to intervene for your intestinal obstruction. But one gastrointestinal surgeon stood out and said that, to improve the quality of life, I will help you. And he explored. He was able to do a resection anastomosis, and the intestinal obstruction cleared. But unfortunately, 1 week after the surgery, this patient developed a burst abdomen, developed sepsis, multi-organ failure, and succumbed to the illness. And when she succumbed to the illness, the husband of the lady came and spoke to the surgeon and said, "Thank you so much, doctor. You did your best." So the doctor felt satisfied and he thought the matter was over. But 1 week later, he gets a legal notice saying that, he was negligent in his care. So he thought he had done everything perfect. But then that was not to be. And so he called up the patient's husband and said, "What is this? What have you done?" So he said, "Doctor, don't worry. You did everything. But I think that, when I put up this case, unki yaad rahegi, I will always have the memories of my wife. And whenever I go to, our legal procedure is always long drawn. So this might go on for another 10, 15 years. So whenever I go to court, I will remember her." So these are the times that we are living in. So even for those who are accomplished and perfect in their medical practice, this is definitely for you in the evolving times. And, patients' expectations, the mismatch of this expectations is what create situations like this. Patients expect us to be kind and compassionate, to have awesome skills, to have excellent communication skills, to give free service most of the time, to do all surgical procedures with zero risk, superhuman expectations, and only somebody like Superman perhaps can do it. And with our human frailties and fallibilities, I don't think it is humanly possible. So this mismatch between this, on one side, doctor who thinks that he is doing his best, and the patient whose expectations are too high is responsible for the unhappy or disgruntled patient. So these days, practicing medicine, you have moral dilemmas, you have ethical proprieties, everything to be taken care of. And if you overstep on any of these minds, you have an explosion in today's times. So let me just give you some basic concepts. So we know that ethics, morals, legal aspects, all these terms are used very, very sometimes very synonymously, and we know that somewhere all of them mean the same thing. They all mean doing what is right. So ethics is doing what is right. Morals is doing in what I think or what you think is right, and medico legally appropriate is actually doing according to what the law of the land thinks is right. So for example, if you find a purse with money lying on the road, the law of the land says that no, you should not try to possess it. It is somebody else's. So ethics actually tells you that yeah, you should stay away. You should not pick up the purse. So ethics and law of the land more or less sometimes matches, and your morals sometimes takes you to that next step where you actually take the purse, try to find out the rightful owner and return it to him. So this is a little bit of the fine difference between these three terms. So whenever we open the newspapers, almost every day, these are the headlines that, this has become almost common practice. And I'm sure no day passes without a headline like this, because negative news is what our media loves to report. And in everything, if you actually read between the lines, there are a lot of things hidden in each of these headlines. So, most of the times, because of this trial by media, doctors or medical practitioners are already deemed guilty until they are proven innocent. And if you see some of these headlines here, also try to create an emotional impact, by telling something more about the patient, like 9-year-old, freedom fighter, somebody suffering from COVID. So the public opinion is already generated against the medical community. And when public opinion is generated against the medical community, it is often a license for violence also against doctors. And if you read this very, very carefully, sometimes there are also hidden advertisements in these articles. Some medical legal lawyers who are trying to advertise corporate care, where things are little deemed to be better is being advertised. Medical insurance, indemnity insurance, security agencies are trying to sell their product. So many people are working through these behind the scenes, behind articles like these. So what we would be doing today is that what I intend to do is, because of the various incidents where frivolous negligence charges are rising, they're like a noose around the doctor's neck. We will hopefully explore a few basic concepts, misconceptions, how we can survive if at all, we are always likely to be in this high risk zone, and how we can bail ourselves out of it. A little bit about informed consent and record keeping, basic principles of medical ethics. This is probably a little bit offbeat from the main topic, but we'll just see where ethics and legal aspects sometimes merge together, and what are the evolving concepts. So I will cover this topic on the basis of these 7 questions. These 7 questions probably will address almost everything that comes to our mind when it comes to medical negligence. So the negligent doctor, does he really exist? Because as doctors, we always take pride in the work that we do, in our conscientious nature, in our honesty, in our skills. So does a negligent doctor really exist? Who is the victim of negligence? What are the redressal mechanisms for the patient from a negligence perspective? Which are the high risk situations where each specialty of medicine stands? That some specialties are more vulnerable for medical negligence claims. What are the survival tactics and bailout mechanisms? What could be the punishment? That is what always worries us. How long can this drag on, and what can happen maximum to me? And what are the lessons learned from this? So the first question is that, is this negligent doctor an imagination or a reality? So, we know that we are people of honor. We usually, take reasonable care of the patient. We treat the patients always to the best of our abilities. We have reasonable skills. We always, do all these things which are expected out of us. That is why there is an unwritten contract between us and the patient, which is known as a fiduciary relationship. So we always act in good faith and candor for the patient. But sometimes in our day-to-day functioning, we might omit to do something which a reasonable man would do. For example, you would not have probably diagnosed a meningitis in time and started antibiotics, which could have resulted in harm. Doing something which a reasonable and prudent man would not do. Like, for example, you might do a surgical procedure like something as big as an amputation on the wrong side. So this probably is the concept of negligence. So we have a legal duty to exercise due care to our patients who come to us. And if we breach that duty because of doing something or not doing something which a reasonable man would do and cause damage, all these three together is necessary for negligence. Suppose if we just have the first two, you have a breach of duty, you fail to start, say, antibiotics for an infection in time, and then it doesn't result in harm, then you really don't have enough stand to claim medical negligence. So this, if you see it from a philosophical perspective, now there is an increasing sense of rights in the patient. So when there is a right of a patient or right of a human being which is compromised, then the whole concept of making that person whole again is there. So if you have a deformity or a physical harm, then you have to compensate for the harm suffered. And the second aspect of it is when you compensate, the person who is harmed also feels that you who have done him harm should be punished. But in a legal sense, for any criminal act, you need two things. That is a criminal mind and the act itself. And usually in medical negligence or in criminal medical negligence, it's not a planned offense, or it is not something which has happened with a lot of pre-planning. So, it's difficult to get both these two together to fit in the actual concept of a criminal negligence. So the new concept or the new evolving Bharatiya Nyaya Sanhita is something which we have all heard of. It's actually not much different from the Indian Penal Code, IPC, which is almost 150 years old. It's just that there are a few changes. So the one of the changes is that BNS 106 is what addresses medical negligence, and the concepts are just the same. If an act of negligence is committed by a registered medical practitioner. The only additional aspect in this is that previously negligence did not have too much of penalty. Here the penalty is, if you see, is an imprisonment up to 2 years and a fine that can vary depending on the extent of the negligence. So now today, if you ask me, if some of you in this from a legal perspective says that I want to you sue all these people because I'm not happy with Dr. George's talk. Is that possible? Definitely. In a legal sense, if you look at it, yes, you can sue these people who have taken away your precious time from 8 p.m. to 9 p.m. on a Sunday evening, precious family time. So this is the evolving legal concepts of why people actually feel that they have not got their best when they apply when they come to a medical practitioner. So the second question is that who is a victim of negligence and what are the redressal mechanisms? So if you see historically, medical practitioners had a paternalistic role in society. So whatever a doctor says was accepted as, as law, and it was accepted, no questions asked. But the earliest times, there were a lot of very, very harsh punishments to the earlier physicians, including maiming and causing them harm. So this is some of the earliest, the punishments executed in the evolution of the concept of medical negligence. So many of the doctors in current era, this is a statement given by one of the famous chest surgeons who says that all of us, even the hardworking and conscientious, are vulnerable to litigation. So what are the remedies for the disgruntled patient? So since time immemorial, one of the earliest remedies was civil law. So you can always file a case, a disgruntled patient can file saying that doctor failed in duty or he violated the contract of the consent that I had with him. So civil law, usually before the Consumer Protection Act came up, we'll come a little more detail into that. The civil law was the only recourse available. And you could also complain to professional regulatory bodies like the Medical Council of India. And you also had the option of criminal negligence, but criminal negligence was very difficult to prove. So civil law, one of the landmark cases which came up which was in civil law for medical negligence and with a compensation of 33,000 rupees. So that was before the Consumer Protection Act. And most importantly, in today's times, it's more the trial by the print media, the social media, which has already caused so much of harm to the doctor that even if he is absolved of the case in the long run, the harm is already done. So this is a very landmark case where doctors were actually brought under the purview of the Consumer Protection Act. The Consumer Protection Act actually came about in 1986, but it was in 1995, almost about 9 to 10 years later that medical services were for patients. So patients could easily litigate their doctors, and they probably didn't even need a lawyer to argue their case. And even sometimes, it's a matter of great debate whether free services executed in government hospitals are also covered by the Consumer Protection Act. So there were a lot of cases where even free services were considered under the CPA, Consumer Protection Act. And this is a landmark change in the medical legal climate of the country. So one of the terms that is very commonly used is the FIR, and we are always scared of this. FIR is actually the first step in initiating a criminal investigation, and it is mainly for criminal cases, and very rarely can it be used for medical negligence, but it has been used. And it is basically any crime against the state, any offense against the state. So can an FIR be registered for medical negligence? Yes. So I'll come to that in a few slides later on. So FIR against doctors for medical negligence, it is usually sometimes frivolously done by policemen, especially hype about something. So, but they are not actually permitted to do that. And the Supreme Court has actually very clearly clarified what is gross negligence versus ordinary negligence. And they can always do it only as per law. They are mandated to have a preliminary inquiry along with experts, with an expert committee before an FIR is registered against a doctor. And always alternate avenues for redressal have to be considered before. And there should not be any automatic arrest. And one of the landmark cases is, for those who are interested, Jacob Matthew versus the state of Punjab. It's one of the earliest cases where the concept of criminal negligence was very much clarified, where a patient lost his life due to oxygen not being given in time. And then it was charged as criminal negligence, but the Honorable Supreme Court of India did not accept it as criminal negligence. So in any legal conviction, the first step begins with investigations, interviewing witnesses, collecting evidence. Second step is, if there is sufficient evidence found, an arrest may be made. But often it is not enough for medical negligence because you need to consult a board of experts. And the third step is charging. So once you have collected your evidence, you prepare a charge sheet, and then you have an arrangement where when the case is filed in court, the accused appears in court, and then he pleads his cause. And then there are pre-trial proceedings where there is motions to suppress the evidence, there is plea negotiations, and then the case goes up to trial, and the defense has the opportunity to present his case or her case. And then finally there is the verdict which comes out, and then finally the sentencing is the last stage. And you also have the option of appealing in a higher court. So from the High Court to the Supreme Court, or from the District Court to the District Commission to the State Commission and the National Commission in the Consumer Court. So this is a little busy slide, but the basic steps in medical negligence is first, investigating officer. If the patient is dead, then the key evidence is basically the autopsy examination. If the patient is alive, then so the body of experts hears both sides. There's an investigating officer from the police side as well. And then there's an expert opinion which is given on negligence. And if there is negligence deemed, then an FIR or a civil suit can be filed. And if there is no negligence, then the charge has to be dropped. So this again is a little more finer details of it. So initiation of the process, then a charge sheet is filed before the court, then the court will give summons, then there are pleadings, and then there is trial, and then you have an option to appeal. So what you would see is that though the procedure is is quite streamlined, what is not clear about it is the time duration. So how long this will take in our Indian penal system, you can never be sure about it. So it can be both, it can be frustrating and vexing both for the doctor and also for the patient who has suffered harm. So civil case or criminal case. So usually most of the basic medical negligence accusations are civil cases. Some of the times it is criminal case, especially, in case of where the evidence speaks for itself, in case of, say, a wrong side surgery, or sometimes a serious medical negligence. So in case of civil cases, the burden of evidence lies on the patient or the complainant, And in case of criminal cases, usually the prosecution, that is the state, the government pleader, the burden of evidence lies there, and also on the doctor who has to prove his or her innocence. So these are the where the complaint is filed, civil court or the nation, and directly in the police station. So which very common question that comes to our mind. So in our country, it is the specialty of gynecology and obstetrics which is highest in the negligence claim. But world over, especially this is a study which was published in NEJM in 2011, which says that neurosurgery is the highest. But then most of them, if what you see here in orange here, most of them actually were settled out of court by alternate dispute redressal. So you would see that almost all specialties of medicine are vulnerable. Even what you thought was very, very safe specialties of medicine perhaps are also extremely vulnerable here to medical legal negligence claims. And in countries like the United States, where insurance funded medical care tops, about 88% of physicians were likely to be sued by the age of 45 and 99% by 65. In India, these figures are gradually rising, and we probably would also see the same figures in the next few years to come. So which are the high risk situations is the next most common question which comes to our mind. So we often think that, when there is a complication of a treatment, like a surgeon who feels that, his patient who has had a wound infection is likely to sue him for negligence claim. It's not actually so. When we see what is the definition of a complication is an undesirable, unintended, and outcome of a surgical procedure, but a direct outcome of the surgical procedure, and would not have actually happened if the surgery had gone on well. So this is a complication definition, but complication doesn't mean negligence claim. As I told you in that real life example, most of the time, sometimes your negligence claims come from those patients whom you thought you would have done a very good job. Okay, but the reasons could have been something like you had some communication gap with the patient, or their expectations of the treatment did not match what you would have explained to them about. So complications or sometimes negative outcomes are if somebody who's not cured of an illness, somebody who has a metastatic malignancy or who does not get relief of symptoms, okay, they are all under the term negative outcomes. So sometimes you have sequelae. Sequelae means that, in neurosurgery, we sometimes do surgical procedures on eloquent or critical locations of the brain. So they sometimes have a compromised function, but that function over a period of time recovers. So that is sometimes a sequelae of the surgery. We really don't take it as a complication. Or persistent symptoms. All these are sometimes, risk factors for medical legal claims. So complication is a very, very broad term. It's a very vague and a term which has got a lot of lack of clarity, ambiguity in its definition. And when we hear that, the surgeon immediately becomes defensive, the patient goes into a litigatory mode, the hospital authorities go into a damage control mode. And for the press reporters, always it's a very interesting story, which they pursue till the next interesting story comes up. So in today's world, it's no more a doctor and patient sort of relationship. It's a provider of healthcare and purchaser of healthcare sort of relationship. And most importantly, what we have to remember in medical negligence is that you always have the first victim, that probably is the patient, and the second victim, that is all of us, the medical professional, is somebody we have to always think about. And probably some of you would have heard this about the incident about Dr. Archana Sharma, who was obstetrician gynecologist in Jaipur, who took her own life in 2022 because of the vexing problem of a very frivolous litigation due to a postpartum hemorrhage, which caused a patient's demise. So all of us perhaps stand the risk of being sometimes the second victim in medical negligence claims. So who are the potential litigants? This is from a publication in 2014. The top 5 causes in the West are surgical site infection, technical error, lack of information about the surgery, expectations, the mismatch between expectations and outcome, delayed diagnosis, and sometimes when you designate the surgical procedures to trainees, claiming lack of supervision. So communication gap, unsatisfied patient, adverse events, unreal outcome expectations are the commonest causes. The usual negligence claims are that the doctor acted beyond his level of skill or competence. Failure to attend. When I attended, I came to the casualty, the doctor was not available, or he went on a visit somewhere else. Diagnosis errors in treatment, failure to communicate, which is something which is easily correctable. Surgical substitution. I thought Dr. X will do it, but actually it was Dr. Y who did it, and I came for Dr. X. Vicarious liability, where you are responsible for the errors for every member of your team. It could be a resident training under you, it could be a nurse in your ICU. You are responsible as the captain of the ship. So the next question which comes to our mind is, what are the survival tactics and bailout mechanism? So there is always a saying which comes up in Hindi movies many times, that 100 गुनेगार को सजा हो तो भी ठीक, पर एक भी बेगुनाह को सजा नहीं होनी चाहिए. In other words, even a single innocent should not suffer due to any sort of legal loopholes. So in other words, the law is sometimes always on the side of the doctor, but we have to argue our cause in the right way. If you see, the rate of successful medical legal claims is still not very high. Is in all over the world is only about 15 to 25%, but it is the death or the trial by the media and the trial by the agonizing wait till this exoneration of guilt comes, is what really gets on the nerves of the medical practitioner. So if you see, this is a newspaper report which says that there were 25 medical negligence FIRs. Imagine, FIR is criminal negligence, but not even one conviction. So you can imagine what these 25 FIR registered doctors would have gone through till that conviction or till they were exonerated, which would have taken so many years. It would have taken at least 7 or 8 years sometimes to get their name exonerated. So what is, often the question that comes to our mind is that, I am not the best laparoscopic surgeon, or I am not the best cataract surgeon, and this so-called complication happened to me. Could the patient sue, saying that, he was not of acceptable skill, or he was not acceptable in his standards of care? So the answer is no. So you don't have to be the best, say, brain tumor surgeon in the world, or as claimed by so-and-so or professional regulatory bodies. You have to be having just what is known as a reasonable skill. And in legal sciences, these are the two tests which are used to identify what is reasonable skill. So Bolam test is actually based on a landmark case which happened in the United Kingdom, where a young man was not given a muscle relaxant during the time of electroconvulsive therapy. So during the time of an ECT for psychosis, he developed fractures, and then he sued for negligence. And then the court looked at it and asked many of the professionals, as, do you usually give muscle relaxants? So many of them said, a vast majority said that we don't give, it is not routine practice. So that is why this has been accepted as a standard of care. What is the standard of care? The Bolam test. So the another test which came up in 1996, because everything could not be answered by the Bolam test, was the Bolito test. So the Bolito test again is based on a landmark case. So you will see a lot of medical negligence acceptable standard skill cases, even in Indian judgments, which mention Bolam test and Bolito test. Bolito test actually means that now if the court takes the opinion of a group of professionals. Now in Bolito's case, what happened was that there was a child with a severe respiratory infection due to diphtheria, and his airway was completely compromised, and he could not be intubated in time and suffered brain damage. So the doctor who was defending the case said that because it was a untreatable or uncurable illness, I did not intubate. But then when an opinion was taken from a group of people, there was a difference of opinion, whether intubation was required, or a group of experts, intubation should have been done. So then in this case, the court can make a logical analysis. So the judge can make a logical analysis, though probably he might not be from a medical background. So that is where the legal system has got some leeway to make their own judgment beyond what a body of experts may feel. And that is known as the Bolito test. So what is the redressal mechanism for the doctor? So we have legal support system, in other words, lawyers to support us, medical indemnity, expert lawyers. We have our regulatory bodies like the IMA, who have got professional indemnity insurance. Most importantly, we have alternate disputes redressal. So many of the lawyers have their support systems where they can have out-of-court negotiations and settlement. And all settlements are always based on the merit of the case, saying that, you did your best in the best circumstances with the best skills available by you. And the defense for the doctor is often, I did my best as per the primary health center during the time of a snake bite, and you did not have, say, anti-venom. So probably in that circumstances, you did your best, and you have to strive hard to prove that conforms to standard adverse event rate. Now, if there is a 1% complication rate, your patient who sued for negligence might be that 1%. There was no deficiency of care. Sometimes there's a mass casualty, a bomb blast, an earthquake, where you have 100 people coming into your casualty. And would you be able to give the same efficient care that you would have done had one patient or two patients come? So that happened in the heat of the moment. Suboptimal facilities, contributory negligence, where sometimes you have prescribed treatment to a patient, he has not adhered to your prescriptions, that is contributory negligence. And vicarious responsibility is when you take responsibility for your subordinates' problems. So what we think is medical negligence sometimes is not. So written consent not taken is not sometimes medical negligence. So there's a landmark case which you can go through. Not getting desired relief of symptoms. Again, there is a landmark case to support that. Giving precedence to one patient over another. You can imagine what all cases have come under the ambit of medical negligence. So again, there is a landmark case to support that. Not providing an ICU bed when unavailable. You have this situation many a times. So even that there is a landmark case. And refusing to treat an elective patient. In today's era, you probably have the right sometimes to refuse an elective patient, who might come to you at an odd hour when you are not really prepared to see him. But emergency care you are often expected to give as per the duties assigned to a medical practitioner. So what is the punishment or penalty? This is what worries all of us. So gross negligence, which is a very, very rare criminal charge, can happen when there is sometimes res ipsa loquitur. That is, when the evidence speaks for itself. Wrong side surgery, say a retained surgical instrument, and or death due to a rash and negligent act. But often this conclusion has to be reached by a body of expert. And this is the only situation where sometimes you can have a cognizable offense where you can be arrested without a warrant, but it is still bailable. So this is the previous era when the IPC used to be in vogue. The same thing now has shifted to the BNS 106. So all these three are now covered in BNS 106, where death by negligence, a rash and negligent act to endanger life. So there are a lot of examples which can fit into this. But then you have your ways to find a recourse or defense mechanism in even gross negligence. So what are the penalties? Fine, compensation, legal restraint, imprisonment, very rare, but can happen in criminal negligence. Professional isolation, this is what we are always worried about. And most importantly, the heartburn due to mal-reputation, legal charges, loss of work focus, all these actually take a heavy toll on the medical practitioner. So do we need this fault finding is the next question which comes to our mind. So, whenever there is a medical negligence charge against us, the first thing is that we try to absolve our name. There is firefighting, damage control mode. We become demoralized, we become defensive. And we somehow, in the whole exercise, we lose the lesson. And the lesson sometimes is to inspire a higher standard of care and to build up further expertise. And probably there might have been something that we could have done better. So that sometimes is lost, because there is so much of negativity, so much of, we have so much of reaction of defending ourselves that we lose this lesson. And probably the way to solve this or to avoid is by having a system what is known as the no fault liability. So some of the European countries actually have that. So you would see that, in the history, there has been a Chernobyl nuclear disaster. There was a space shuttle Challenger space shuttle disaster. So we know that, the Kalpana Chawla one, where the lives were lost, but finally there was no accountability or fault fixed at a single individual. It was a systemic failure. Now we are aware of the the Air India crash, where we are still groping in the dark to find out the reason. So rather than finding out an individual failure, a systemic failure, probably all of us are at fault to some extent. Though probably the wrong side surgery was done by actually the surgeon. There could be a reason for that. There could be an overloaded system There could be somebody who was supposed to do a preoperative check to mark the correct site has missed it. So it could be a systemic failure. So we need to shift focus from as a society, as a country, as a medical system, a fault finding philosophy to setting right a system's failure and preventing future harm. So the question we need to ask is not whose fault it is, how to avoid the fault and how we can rectify it in the future. So what are the common misconceptions is that we need an ultimate and utmost skill to avoid medical negligence? No, some of the most skilled people are on the wrong side of the law. Adverse events reach cause malpractice claims? Absolutely no. Sometimes your happiest patients might be, whom you think are happy, might be responsible for the malpractice claim. Informed consent protects you against all litigation? Absolutely no. Informed consent may be interpreted in so many ways by different people, and you always fear that you could be arrested as an unbailable offense. Again, that is extremely rare, and almost all criminal negligence cases in against doctors, bail is always can be obtained. And we sometimes also feel that to err is human. That's true, but then we can always keep getting better to avoid it in future. So the success rate in claims, as I said, is about 15 to 25%. But the worries are always the trial by media, the sensationalism, the commoditization of medicine, defensive medicine, increasing the costs, communication failure, lack of legal reforms, and an increasing breed of medical malpractice lawyers who are always constantly trying to advise the people that there is something wrong going on, something harm going on. You have to get it right. So state-sponsored no-fault social support program perhaps in future would help to support victims of medical negligence. That is both from the doctor, that is the practitioner's perspective, and the patient's perspective. So what is the fallout of these frivolous litigations in the current era of the Consumer Protection Act? We have blow to the reputation, we have over investigations, defensive medicine, most importantly, impersonal medicine. We don't have that sacred doctor-patient relationship anymore. Overbearing costs of medical indemnity insurance. There is a general cover-up attitude rather than trying to learn the lesson. There's a tendency to refer and refuse care, immediately. And the whole thing is about saving one's skin by all means. So an ounce of prevention sometimes is worth a pound of cure. So what we can do, basic things at our level, is to have our error avoidance checklists and protocols, having multiple people check again and again, especially if it's a surgical procedure or something which involves a lot of people. Secondary prevention is check the medical records, check the informed consent, make sure it is done in the right way. Tertiary consent is after it has happened, that is take legal advice, have preventive medical indemnity insurance. And quaternary is to have medical legal reforms, to have support groups which will argue your cause. So what are the survival tactics? Again, easy to put it in the form of these R's. Have good rapport with the patient, make sure your rationale for interventions is perfect, you maintain good records, all the remarks that you made should be very calculated without hurting sentiments. Treatment, everything should be very well balanced, respect good results as per the patient's expectations, and make them aware of the essential risks. Some landmark cases which will help you to clarify your concepts better. So one of this is a patient who underwent disc surgery. So I have deliberately avoided cases in Kerala so that some of us sometimes who might have been involved with these cases might have some of the old memories coming up. So just to clear the concepts, I have put general cases. So this is a very landmark case which happened in the United Kingdom, wherein a patient underwent lumbar disc surgery and developed post-operative cauda equina syndrome. So the cauda equina syndrome is usually rare after an uneventful disc surgery. So it is when it's a rare complication, the patient was sued the doctor saying that he was not informed about this risk. So the House of Lords said that for rare risks, you really don't need to inform. You should be aware that there could be a risk like it. So the example quoted was the casino example. Now, a person who goes to a casino knows that his probability of winning that jackpot is very less. He knows that the risks of losing the money are more higher, but he still goes there. So this is a legal argument which was provided. So a quick word about consent. Consent rests on the basic principle of autonomy. So all of us have right to our bodies. So we need to have free decision making. We should be informed about what is going to be done with our bodies. And most importantly, while we are taking the decision for consent, we should be in good capacity. We should be able to understand the consent. So consent is not valid, especially if it is obtained by influence, fraud, misrepresentation, by mistake. So all of these words, have got so much of heavy legal meaning that you can have almost a 1 hour webinar on each of these words here. And when consent is not necessary, there is a legal provision that, especially when you are providing life-saving emergency care, you probably can, waive consent till probably a right person or the right situation for consent comes up. You can waive it for a future date or take it from a suitable authority in your hospital, say like a registrar or a CMO or somebody who is authorized in your system. And most importantly, you have to document consent. So in some way, in the form of a written consent, whether a video recording of your consent is essential, it's not really essential. But if that is your way for documenting and proving the point that you have taken consent, then so be it. And this is the descending order of decision making power. Now suppose if you don't get a suitable decision making, you are not able to give consent and you are getting consent by proxy, then this is how the court appointed guardian, then these are the people who have the first rights, then the spouse, the parents, and this is the descending hierarchy of consent by proxy. So one very landmark case and very interesting case, some of you would be aware of it. Most gynecologists are aware of this. So this is a very interesting case which happened in Delhi. So a young lady called Samira Kohli was undergoing treatment for endometriosis, and she was undergoing a diagnostic laparoscopy. And at that time, they found that it was very diffuse endometrial deposits and they wanted to do a salpingo oophorectomy. So the consent was taken for a salpingo oophorectomy during the diagnostic laparoscopy from the mother of the patient. So the patient probably was just told orally about it, but there was no written consent. So when the patient woke up from anesthesia, the patient alleged that consent was not taken, and the National Commission, it was put up in the Consumer Court. And when it came up for hearing in the Consumer Court, the National Commission actually said that consent was taken from the mother, that is sufficient. So it was deemed not negligent. The patient appealed in the Supreme Court, and then the Supreme Court ruled that this is negligence because adequate consent was not taken from the patient. So you can see that two courts of law can have so much of difference of opinion because legal sciences just work on basic legal principles. So that basic legal principle sometimes can be interpreted differently by different legal system, different courts of law. So that is why always, if convicted, going for a next level of appeal might actually on a fresh day completely change the stand on the case. So this is a very important case. Another important landmark case is the case of Prashant Dhanaka. So he was an IT engineer who underwent surgery for a spinal cord tumor, and then he developed post-op paraplegia. So this was a tumor which was not really involving the spinal cord. It was just displacing the spinal cord. So he sued for medical negligence. The compensation given by the National Commission was 14 lakhs. And then the Supreme Court further enhanced it to 1 crore. And this is a landmark case because it gives you an idea about the concept of compensation in negligence. So recently, not very recent, about 10 years ago, there was a very landmark case where the Supreme Court awarded 11 crores as compensation after about, I think, 18 years of the case. So this is a famous case involving a doctor called Anuradha Saha. She passed away due to toxic epidermal necrolysis. So she was a doctor from the United States who came to Calcutta. And when she took treatment for a skin lesion with a dermatologist, the dermatologist first prescribed steroids and some local cream. But then over a period of time, she developed toxic epidermal necrolysis, worsened, had multi-organ failure, and passed away. And when the compensation was, the case went on for a long time because the husband was a doctor. He was able to get the right witnesses. And after about, I think this happened in 1998, and the judgment came in 2020. I think 2013 or 14, about 10 years ago. And then the whole concept of compensation works on the principle of restitutio in integrum. It means getting back the patient what he or she has lost, restoring it back. And the compensation is based on this formula. So 70 minus age and then annual income plus 30% for inflation minus 1/3 for expenses. So this is a formula which is actually used by the motor vehicle department for where the state pays victims of motor vehicle accidents. So the same formula, unfortunately, is used for medical negligence compensation as well, which is not really fair because it heavily relies on the income of the patient. It means that Elon Musk's life is more valuable than my life or your life. Okay, so imagine if this patient is Elon Musk or Mark Zuckerberg or Mukesh Ambani. You might no country or no state or no individual will ever be able to pay the compensation for him. So this is the compensation actually which was demanded by, in this case of Prashant Dhanaka, loss of future earnings, present burden of expenses, damages to other family members. And finally they asked for 4.6 crores and the Supreme Court, I think, gave 1 crore. So the philosophy of compensation is for coverage for the harm done, retribution, that is a sort of punishment for the doctor or the medical system, and deterrence to avoid it from happening again. And loss of income, medical costs, future medical costs, all these are involved in the process of compensation. And then the sad part of it is this will lead to, this actually leads to a system of defensive medicine and more expensive healthcare in future. So one of the other recent concerns is the POXO Act, which I think all of us probably need to be aware of. So you would have just seen a small child in casualty with a wound which is bleeding. You would have just put a dressing in good faith. And when you go back home, the child goes back home, recovers from the wound, and few days later, you find that you're on the wrong side of the law. So whenever you have a report, when you have suspected violence against a child, which could fall under the purview of the POXO Act, okay, keep a high index of suspicion. And we have a landmark case in Kerala as well, where deliberate omission to report the case. Sometimes, it's very difficult. The word deliberate is very important here. You might try to absolve yourself saying that I didn't know this was what happened, but not always you would succeed in proving to a court of law that you had only inadvertently or not deliberately omitted to report the offense to the police. So one of the very important, patient privacy acts in the United States is the HIPAA Act. In our country, we don't have anything obviously like this. There's no Indian equivalent. But whenever we are, putting up our medical victories and achievements on social media, we need to be very, very careful. So something like this, my Bollywood actor patient is doing great, can invite a lot of problems. So we have to be very, very careful with our social media posts. And a quick word about medical records. Now, this was the medical record in our hospital in 2006, and this is the medical record in 2021. So we have evolved significantly. Though this looks a little more neater, looks very much composed and very much suave and sophisticated, but it's not always so. There were a lot of things which were done better in the pre-EMR electronic medical record era. So we have more scope for creativity, expression, illustrations, diagrams. Here it is more of drop-down menus and template-based. So there are different perspectives when you find a medical record. There's a patient's perspective, there's the surgeon's or the doctor's perspective, there is a hospital administrator's perspective, and there are a lot of facets to it. There's a medical legal facet. So whenever you are writing a medical record, always be prepared that it might come under scrutiny and do it the right way. So whenever you're speaking to a patient, always be prepared that you might be being recorded. You might be actually working, you may be like Mammootty or Mohanlal, lights, camera, sound, action. You may be actually, being recorded. So do everything the right way so that even if you are being recorded inadvertently without your knowledge, it's fine, no problem. What you're doing is your duty and you're doing it to the best of your abilities. And we often, we put too much of emphasis on documentation. Sometimes we document, you do it, but you didn't document it. Like it happens in emergency care, CPR. Sometimes you didn't do it, but you did document it. Like you write atropine, adrenaline. So documented doesn't mean that it is always done. So what matters in today's world is it documented? Because that is deemed to have been done. So there's a mismatch between doing and documenting, though we are trying to make this mismatch very even. And sometimes so much of documentation actually distracts and dilutes the standard of care. There is scope for more error. Documentation becomes more important than caring or curing, compromises medical care, causes stress and physician burnout. And there is always a very interesting study to support this. More documentation really doesn't translate to better care, and interventions which to improve documentation fail to change the severity of illness or risk of mortality as shown in this study. So, but there are situations where EMR has actually helped to improve the quality of care. So the tacit balance between documentation and doing has to be maintained, and doing it matters more than documenting it. So a quick word about ethics in medical practice. So we know that ethics actually works on these four basic pillars: autonomy, that is respecting the values of the patient; beneficence, that is doing something in the benefit. So whenever you're sure that a surgical procedure or treatment is going to do good to the patient, you advise it. If you're not very sure, then you're not really conforming to that. Is that especially with new medical treatments or new drugs. Non-maleficence, that is don't do anything that is likely where the risk is more than the benefit. And justice, so when you have a rich patient versus a not so well-to-do waiting for the same care, you don't really try to be unjust in your provision of care. That is the principle of justice. So ethics versus practicality dilemmas come up many times in our medical practice. Blood transfusion in Jehovah Witness, clinical trials for recurrent tumors. You don't know whether drug works, but there's a hi-fi trial. There's a patient who can afford it. Emergency surgery in an unknown patient, whether you do best within your skill set or refer to a higher center. Another concern always is ghost surgery, wherein you have taken informed consent, but somebody else actually does the procedure. And there are a lot of cases in legal sciences where ghost surgery has been deemed as medical negligence. So ethics of social media and advertising, maintain the patient-doctor boundaries. So when you're accepting friend requests, be careful. Respect privacy, confidentiality, identifiers, especially when you're putting up your medical achievements on social media. Maintain probably a different professional and personal account. Use social media for patient education and general advice. Okay, don't really need to shy away from it. Use it the right way. Avoid something like medical selfies or surgical selfies where you are taking pictures with your big tumors and things like that. And always remember that you could be always on the wrong side of copyright or wrong side of intellectual property rights if you're not careful. So ethical red tape, now almost there is an ethical committee everywhere for even doing small procedures. Sometimes there is undue ethical concern, and there are areas where actually high ethical concerns are needed, like new drugs, new procedures, which are somehow diluted because of these undue ethical concerns. Data confidentiality, conflicts of interest, intellectual property rights, these are all evolving concepts which we have to be careful about. So rights of the research subject is always the center, but sometimes we fail to understand that even doctors or researchers also have rights. So this is a 11-point norm on medical negligence, which the Supreme Court actually came out. The same things which we had already cited. So the main thing is that this actually talks about gross medical negligence, and criminal negligence charges cannot be really frivolously applied to doctors. And the very important thing is, if there is a difference of opinion between medical practitioners, even that cannot be cited as negligence. And just because one doctor chooses one course of action and another feels it should have been done differently, that is not medical negligence. And it ends with a very, very heartening statement which says that it is our duty not to harass or humiliate medical professionals, and doctors are entitled to get protection. So we need not fear medical negligence, because the law actually wants to consider and respect the care that has been given in a difficult time for the patient, but we have to prove that to the legal system. And let me end with this important message that more than 80% of negligence claims are avoidable. We have to take precautions by making sure that we are sticking to the standard of care, we are having good communication with the patient, ensuring that they have their expectations met, and we can be prepared by having some form of medical indemnity insurance, especially in high risk medical specialties. And don't panic if you're on the wrong side of a medical negligence case. Plead your cause in a logical, ethical, and a legally upright manner. And malpractice claims are not related to the complexity of case. That is what we have to understand. And error prevention and high standard of care are the cornerstones of being on the right side of the legal system. And we have to work to develop the strong bond of doctor-patient relationship, which is corroding in the current times. And we are living in a very, very difficult times where even Humpty Dumpty, who fell from the wall, he can also sue for negligence because somebody told that it's because of loose motor and no warning signs. So in this complicated world, we have to we end up much.